Subcommittee will now come to order, and I'm pleased to welcome you today to today's hearing before the Subcommittee on Crime, Terrorism, and Homeland Security. Today's topic is reining in over-criminalization, assessing the problems, proposing solutions. Last year, on July 22nd, the subcommittee conducted a hearing titled Over-Criminalization of Conduct, Over-Federalization of Criminal Law. That hearing occurred as a result of a series of conversations that Ranking Member Gohmert and I had with former Attorney General Ed Meese and a coalition of organizations, including the Washington Legal Foundation, the National Association of Criminal Defense Lawyers, the Heritage Foundation, the ACLU, the American Bar Association, the Federalist Society, and others. They came to Congress to seek a hearing to discuss the practice and process of enacting federal criminal law, and they came out of concern for what they and many others viewed as an astounding rate of growth of the federal criminal code. Testimony from last year's hearing served as a disturbing illustration of the harm that can and does result from the enactment of poorly conceived legislation. Last year, a year later, they still question the wisdom of continuing the expansion of the criminal code without first taking time to consider and review the process by which the federal crime legislation is enacted. But more than the rate of the federal criminal code's growth, these concerned citizens and groups remain alarmed about the deterioration that has occurred in the standards of what constitutes a criminal offense. There is great concern about the overreach and perceived lack of specificity in criminal law standards, i.e. the vagueness and the disappearance of the common law requirement of mens rea, or guilty mind. Today's hearing is supported by a similarly broad group of organizations, and we'll continue our examination of the issue with the discussion of a draft of their own legislative proposal and review of the findings of a joint study by the National Association of Criminal Defense Lawyers and the Heritage Foundation entitled, Without Intent, How Congress is Eroding the Criminal Intent Requirement in Federal Law. The legislative proposal is notable not only for its content, but also for the fact that such seemingly odd political bedfellows can come together on this common ground issue. The Without Intent report is a remarkable nonpartisan study that raises important questions about the proper role of the federal criminal code and also documents problems that I cited at last year's hearing, vagueness in criminal law standards and a disturbing disappearance of the common law required of mens rea. As all of you by now are familiar with my position on crime policy generally, I've been in office for 30 years, and I've learned that when it comes to crime policy, you generally have a choice. You can prosecute and incarcerate people for so-called crimes, or you can utilize available civil remedies to handle minor infractions. You can do the things that research and evidence have proven will reduce crime and enact legislation that provides clear and fair notice of what constitutes criminal acts, or we can play politics as usual with the emotionally charged sound bites and slogans that sound good but prove not to be sound policy. These kinds of things include mandatory minimum sentencing, 3 strikes and you're out, and after that didn't work, 2 strikes and you're out. Life without parole, abolish parole, or if it rhymes, it's even better. If you do the adult crime, you do the adult time. None of those have been shown to reduce the crime rate, and in fact, the adult crime and time slogan, all of the studies have shown that if you codify that soundbite, you'll actually increase the crime rate. We can see the impact of the unfair and vague legislation at the hands of overzealous prosecutors when we look at the prison population. We now have, on a daily basis, over 2.3 million people locked up in our nation's prisons, a 500% increase over the last 30 years. The Pew Foundation has estimated that any incarceration rate over 500 per 100,000 is actually counterproductive. This massive increase in the number of Americans incarcerated has very little documented positive effect on public safety, while it contributes significantly to family disruption and other problems in many American communities. In fact, we incarcerate now at such a high rate that is actually contributing to crime. We must continue to work on legislation to bring some common sense to enacting federal criminal law in sentencing. We must put an end to the notion that we need to prosecute every individual for every perceived offense and incarcerate every defendant for the longest possible time. We now lock up not 500 per 100,000, but over 700 per 100,000 in the United States, 7 times the world average. And now we'll hear, as we'll hear today, we continue to lock up people for offenses that should not even require incarceration. So the problem has been identified, the challenge is clear, and our purpose today is to hear from experts, practitioners, and those who have been personally impacted by vague and unfair laws about what Congress can do to enact criminal legislation that is fair, provides notice, and is truly necessary. Congress already knows how to play politics, but we need to do things that will actually reduce crime in a fair way. It's now my pleasure to recognize the esteemed ranking member of the subcommittee, my colleague from Texas's 1st Congressional District, the Honorable Louis Gohmert, who is ranking member of the subcommittee.
Thank you, Chairman Scott. Thank you for calling this hearing today. This obviously is the second hearing we've had in the subcommittee on overcriminalization, and that is a topic of particular importance to me. And I also want to welcome our witnesses here today and thank you for your tireless work and dedication to this issue. Organizations including the Heritage Foundation, the National Association of Criminal Defense Lawyers, the ACLU, Cato Institute, American Bar Association, and others have joined together to address overcriminalization and over-federalization. Now, Chairman Scott and I have differing views on the approach to true crimes. In Texas, when you had judges like Judge Ted Poe and Louis Gohmert on the district bench, and we were locking up increasing numbers of people for violent crime, we saw our crime rate go down all through that period. So I know in some places, maybe it's just you got the right law enforcement, I'm not sure, but I know we incarcerated in higher numbers those that were committing violent crimes, and the crime rates did go down. But what we're talking about in this hearing today are things that should not be offenses, things that shouldn't carry criminal sentences as a result of an activity, particularly when there is no mens rea, there's no intent. And from something as minor as failing to stick a sticker on a package with an airplane and a line through it when you've already checked the box that indicates by ground only. But our witnesses have spent so much time studying this issue and preparing recommendations to Congress. And I hope my colleague, Chairman Scott, and I and others on this subcommittee will be able to get our colleagues to move forward with many of the proposals that you have made for us. I would also like to take a moment to welcome two of our witnesses here today, Bobby Unser and Abby Schoenwetter, who have experienced firsthand the consequences of overcriminalization. Mr. Unser was convicted of operating a motorized vehicle inside a national wilderness area after becoming disoriented during a blizzard that nearly cost him his life. Mr. Schoenwetter was just recently released from over 8 years in prison for purchasing lobster tails, not in violation of U.S. regulations, but in violation of Honduran regulations, a charge even the Honduran government disputed. The evolution of the internet and 24-hour news cycles has, in some respects, blurred the lines between state and federal law. American communities may suffer an increase in gang activity, car theft, or sexual assault and call upon their representatives in Washington to respond, though these are normally local crime. Unfortunately, many in Congress are eager to respond to the urgings of their constituents, often without due regard for the proper elements of a criminal statute or other existing federal and state laws. The result is a labyrinth of federal criminal laws scattered throughout many of the 50 titles of the U.S. Code. And much of this occurs despite the fact that the federal government lacks a general police power. To be sure, there are areas of legitimate jurisdiction within which Congress can and should prohibit criminal conduct. Congress has authority to regulate crime in the special maritime and territorial jurisdiction, crime occurring on federal lands, and crime within interstate or foreign commerce. Today, there are an estimated 4,500 or so federal crimes on the books, and still many more regulations and rules that, if not abided by, result in criminal penalties, including incarceration. However, many of these laws impose criminal penalties, often felony penalties, for violations of federal regulations. As a former prosecutor and judge, I support the common law tenet that ignorance of the law is not a defense. And this tenet rings true for crimes which are categorized as malum in se, or they're just wrong of their own. We expect members of civilized society to know it is wrong to commit murder or burglary or engage in an act of terrorism, regardless of what the law says. But today, Americans must contend with literally thousands of obscure and cumbersome federal regulations, and as our witnesses today can attest, a simple misreading of a regulation or ignorance of a regulation can land a person in prison. Our witnesses today will note that a great number of these regulations lack an important element, criminal intent. But an even more fundamental issue is raised by such regulations, and that is whether the prohibited conduct is even criminal in the first place. Should the importation of certain goods, such as lobsters or orchids, in violation of federal or even U.S. regulation, be met with criminal sanctions, or should it instead be met with civil penalties? Should only habitual violations be criminalized, or only such violations that result in personal or property damage? And perhaps most important, shouldn't most, if not all, federal crimes include at least some form of intent to do wrong? Once these important policy considerations are answered, then we can turn to properly constructing the elements of criminality. The growth in criminal regulations has produced a side effect, so to speak, that is equally disconcerting. An increasing number of federal agencies empowered to investigate these so-called criminal activities. We are all used to hearing about the investigations by the FBI, DEA, or customs agents. But what about investigations by the National Marine Fisheries Service within the National Oceanic and Atmospheric Administration, or an EPA SWAT team that runs someone off the road, throws them to the ground because he failed to put a sticker on a package? This agency of the National Marine Fisheries Service is the agency that uncovered the Honduran regulations that Mr. Schoenwetter is alleged to have violated. I say alleged, even though he's done time in prison, that still is an issue. People also may be surprised to learn that the Food and Drug Administration has an Office of Criminal Investigations, or that Medicare fraud is hunted down by agents within the Health and Human Services Office of Inspector General. I mean no disrespect to the men and women of these offices. I only cite them as a means to highlight my concern and why I appreciate Chairman Bobby Scott calling this hearing. That concern being that along with broad sweeping criminal regulations comes a host of investigative agencies eager to enforce them. And we've seen over and over, overly eager at times to enforce them. There's a well-known saying that a prosecutor would rather let 100 criminals go free than to send one innocent person to jail. But I'm concerned that criminal regulations and poorly drafted laws may be responsible for sending more than just one innocent person to prison. I do look forward to hearing from our witnesses and appreciate your helping us bring attention to this issue so that we can convince people on both sides of the aisle, because people on both sides of the aisle are responsible, trying to show America that we know how to fix these things. We'll slap a prison sentence on it when it's not fixing it. It's, in fact, creating even more issues of faith in our federal government. We need to get back to those issues that are within the constitutional mandate for Congress to take care of, not allow regulators to pass regulations that become criminal laws that get people put in jail. And I look forward to hearing your testimony and yield back my time. Thank you.
Thank you. We've been joined by the distinguished chairman of the full committee, the gentleman from Michigan, Mr. Conyers.
Thank you, Chairman Scott. And the two judges that are here with us, former prosecutors also, I'm delighted to be with you. I think this is an important hearing, and I'm glad that you have enough witnesses to help us prove the point. 7, that's a pretty good number. Start us off. My emphasis on this subject is more directed to the way that we're using the drug war to incarcerate people in the United States. We have now over 2 million people imprisoned, which makes us the #1 incarcerator of its people in the world. 68% of people arrested are tested positive for drugs. And so what we need are drug courts that provide diversion and treatment rather than mandatory sentences, which this committee has worked on for so many years. And my concern is that there may be a tendency of my beloved administration to propose to spend even more money on law enforcement than on treating the drug problem as a crisis. And so it's in that sense that I hope some of these 7 witnesses will enlarge upon this point that I make in my opening statement, and I'll put the rest of my statement in the record. Thank you very much.
Thank you, Mr. Chairman. I understand that Judge Poe has a statement.
Thank you, Mr. Chairman. Thank you for holding this hearing, and Judge Gohmert for putting this hearing together again today. Welcome all the witnesses. Good to see Jim Levine here today, longtime practicing lawyer, excellent lawyer in Texas. 22 years on the criminal bench in Texas. You know, in Texas, everything's a crime, and it's almost all of them are felonies. Years ago, we operated under the Penal Code of 1925, which really hammered folks. You know, you leave your wire cutters in your saddlebags, and you're off to the penitentiary. Marijuana cigarette could get you life in the penitentiary of the state of Texas, and numerous crimes like that. And finally, the state got together and decided some things ought to be felonies, some ought to be misdemeanors, and some shouldn't be crimes at all. I say that to say that we in the federal system now, where the general jurisdiction and philosophy for criminal conduct was to be done in state courts. The states were to decide how they wanted to punish folks, even make something a crime or not, and the federal government was to take other roles. We've come a long way since the piracy laws, then the kidnapping laws, then the bank robbery laws, and now we have 4,450 federal crimes. And once again, we're in a situation where everything's a federal crime. And I think that it's time that we deal with this and make some realistic decisions, and also prioritize what the role of the federal government is in labeling things a crime, and even reconsider this whole concept of sentencing guidelines, which tend to be, I think, arbitrary in many cases. So we need to make the decisions what should be federal crimes, what should be handled by local, state authorities, and even reduced to or changed to some type of civil sanctions. And I agree with my friend Judge Gohmert on those issues. We have many compelling cases before us. I just want to mention one federal case that happened recently that is worthy of mention. In Iowa, there was a kosher slaughterhouse operated, Shalom Rabeskin, and he was sentenced to 27 years in the federal penitentiary for some financial crimes. He was investigated for immigration violations, charged with 9,311 charges. Over 9,250 of those charges were dismissed, and he still went to the penitentiary for 27 years because he violated that law, that sacred law, that's the Packers and Stockyard Act, for not paying cattle suppliers within 24 hours of delivery of the cattle, dastardly deed, and got him 27 summers in the federal penitentiary. He was prosecuted even though all cattle suppliers were paid in full, and the latest was just paid 11 days late. But that was a felony, and it is a felony still. He is the only person I know of prosecuted under this act that was passed in 1921. And so this is an example of, I think, really an abusive law. Probably our slaughterhouse operators, if there are any left in the country, don't even know this law exists, but they better pay those bills on time. I'm not going to get into all the complexities of his case, but his sentence was considered excessive by a lot of people. I'm one of them. And it was even 2 years longer than the prosecutors asked for. So the federal judge really was upset about not paying those bills on time. And his account, not justifying any of the conduct, but financial crimes don't seem to be related to the situation, what he was originally charged for, which was immigration allegations. And so he's at 51 years of age, and he's doing, in essence, a life prison sentence in the federal penitentiary. We probably need that space for somebody that's just really an outlaw. But once again, example after example of federal cases, federal prosecution, where maybe the system needs to look again at these 4,500 crimes under the federal system, and then make sure that when we have somebody that needs to go to penitentiary, they go to the penitentiary. I do believe it does deter criminal conduct, especially violent conduct, but we need the space for these folks as opposed to the folks that don't pay their slaughterhouse bills on time. And with that, I yield back. Thank you, Mr. Chairman.
Thank you. We have several distinguished witnesses today to help us consider the issues. First panel, the first witness is Jim Levine, President of the National Association of Criminal Defense Lawyers, based in Washington, D.C. He's a former prosecutor in both Texas and Illinois. He is a recipient of the prestigious award from the ACLU given annually to criminal defense lawyers who personally and professionally exemplify the goals and values of the association and the legal profession. Our second witness is Bobby Unser, a retired race car driver, but he's here not to talk about his racing exploits. In 1996, as we've heard, he and a friend were snowmobiling along the Colorado-New Mexico border. Trapped in a blizzard, they dug for shelter and abandoned their snowmobiles while suffering frostbite, dehydration, and exhaustion. After their rescue, the Forest Service rangers returned days later to recover the vehicles, and he was fined $75 for snowmobiling in a wilderness area. He refused to sign, and following a 2-day bench trial, he was convicted of one count misdemeanor. Our next witness, Abner Schoenwetter, is another victim of over-criminalization. In November 2000, a federal jury found him a hard-working seafood dealer with no prior criminal history and his co-defendants guilty of multiple violations of the Lacey Act, all premised on violations of disputed Honduran law regarding importation of fish or wildlife. Interestingly, the Honduran embassy filed an amicus brief stating that the law was null and void. He served 7 years in prison for shipping lobsters that were under regulation size and transported in plastic bags instead of cardboard boxes. He will be under supervised release for the next 3 years. During my opening statement at last year's hearing on this issue, I referenced this case, and at the time he and his co-defendants were still incarcerated, and I said Congress must understand that we're making law-abiding Americans vulnerable of losing their freedom, their livelihood, their lives when we enact laws that are vague and fail to clearly communicate the illegality and criminality of prescribed acts. He's with us here today and will tell us about his experiences. And after he testifies, Brian Walsh is a Senior Legal Research Fellow at the Heritage Foundation's Center for Legal and Judicial Studies. He directs Heritage's projects on countering the abuse of criminal law and criminal process. Prior to joining the Heritage Foundation, he was with the litigation team at Kirkland & Ellis and a law clerk to Judge Bowman of the U.S. Court of Appeals for the Eighth Circuit. Our next witness would be Stephen Smith, professor of law at Notre Dame School of Law. Prior to teaching, he served with the Supreme Court and Appellate Practice Group of Sydney and Austin and Washington, D.C. He also served as an associate majority counsel to a 1996 House of Representatives Select Committee investigating U.S. involvement in Iranian arms transfers to Bosnia. Witness after that will be Professor Alan Podgor, who is the Leroy Highbow Senior Research Chair and Professor of Law at Stetson University. A former deputy prosecutor and criminal defense attorney, she teaches in areas of white-collar crime, criminal law, and international criminal law. She presently serves on the board of directors of the International Society for Reform of Criminal Law. Our next witness is Andrew Weissman, who's co-chair of the White Collar Defense and Investigations Practice at Jenner & Block in New York City. He joined the firm after serving as the director of the Enron Task Force, where he oversaw the prosecution of more than 30 individuals in connection with that company's collapse. Now, all of the witnesses' written statements will be entered into the record in their entirety. I'd ask each witness to summarize his or her testimony in 5 minutes or less. And to help stay within the time, there's a timing device in front of you, which will start green, will turn to yellow when there's 1 minute left, and red when the 5 minutes have expired. Mr. Levine.
Chairman Scott, Ranking Member Gohmert, committee members, my name is Jim Levine, and I am the president of the National Association of Criminal Defense Lawyers. I am also a practicing criminal defense attorney in Houston, Texas, and I was formerly a prosecutor, having the privilege of practicing before Judge Poe during the time in his prior life when he was a judge in Houston. I appreciate the opportunity to testify today on behalf of NACDL and all of my colleagues in the criminal defense community. No one, including the government, can state how many criminal offenses exist in the federal code or in the federal regulations. It is impossible for practitioners who specialize in this area to know all of the conduct that is criminalized. How then is the citizen to protect against unjust prosecution and punishment for making honest mistakes or engaging in conduct that he had no reason to know was illegal? Duplicative statutes, federalization of conduct traditionally belonging to the states, criminalization of regular conducted business activity or social conduct and interactions, this is over-criminalization. When any of these elements combine with poor legislative drafting, inadequate mens rea requirements, or unfettered prosecutorial discretion, the result is inevitably the victimization of more law-abiding citizens. While I'm here today to speak about over-criminalization, Representative Conyers, NACDL would welcome the opportunity to return at another time and discuss the issue of problem-solving courts, as we have published in our report, and discuss the issue in drug courts and diversion in particular, in answer to your earlier question in your opening remarks. On July 22nd in 2009, this subcommittee came together under the bipartisan leadership of Representatives Bobby Scott and Louis Gohmert to learn about our nation's addiction to over-criminalizing conduct and over-federalizing crime. Supported by a broad coalition of organizations ranging from the right to the left, last summer's hearing received attention from national media and ignited the over-criminalization reform movement. NACDL and the Heritage Foundation dedicated themselves to analyzing the legislative process for enacting criminal laws and producing a groundbreaking, nonpartisan joint report entitled Without Intent, How Congress is Eroding the Criminal Intent Requirement in Federal Law. So basic is this issue that the nation's practicing criminal defense bar has collaborated with a conservative think tank to produce the Without Intent report. Just 1 month after its release, over 300 articles from news organizations spread coast to coast were written about the report. The press had taken notice of this unlikely coalition, the American public's growing concern over the current over-expansiveness of federal criminal laws, and the broad bipartisan support for reform. The interest extends beyond the press. NACDL has received requests for copies of the report from members of every branch of government. But another side of this problem has received even more attention by members of this chamber and the national media alike. The personal side, or as we refer to it, the face of overcriminalization. Presenting the face of overcriminalization is critical to raising public awareness of this problem. For this reason, I will spend the remainder of my testimony doing just that. During last summer's hearing, members of this subcommittee heard the heart-wrenching tales of two victims of overcriminalization, Christopher Everson and George Norris. From this testimony, we learned how an unwarranted prosecution can destroy the lives of productive, law-abiding citizens and community members. Sadly, their stories are not unique. Consider the case of Georgia Thompson, which is described in more detail in my written testimony. Georgia was charged and convicted of violating 18 U.S.C. Section 1346, commonly known as the Honest Services Fraud Statute, for conscientiously doing her job and doing it well. Upon hearing oral argument, the Seventh Circuit panel of judges found this prosecution so ill-conceived that it immediately reversed her conviction and ordered her release without delay. The Honest Services Statute did receive a measure of comeuppance in the Supreme Court this past term, but not before its carnage was visited upon untold numbers of victims of overcriminalization. You may ask yourself, how could this happen? An innocent, hardworking civil servant ends up spending 4 months in prison just for doing her job. Georgia Thompson is the face of overcriminalization. Her story is evidence of the harm caused when Congress fails to draft statutes clearly and with adequate mens rea protection, when prosecutors stretch already broad statutes to reach everyday conduct never intended to be criminalized, and when judges inconsistently apply rules of interpretation. The Honest Services Fraud Statute, responsible for victimizing countless law-abiding individuals, is the poster child for this problem. The failure of Congress to define criminal conduct in a clear and specific manner allows and quite possibly encourages prosecutors to charge all sorts of innocent conduct, from errors in judgment to behavior that is the slightest bit unsavory. Rather than enact a specific, precise criminal statute, Congress instead relies on prosecutorial discretion to shape the contours of criminal offenses. The story of Georgia Thompson, as well as Christopher Everson and George Norris, demonstrate that such reliance is misplaced. Today you will hear from two more victims, Abner Schoenwetter and Bobby Unser. Abner spent nearly 6 years in prison for shipping lobster tails in plastic bags rather than cardboard boxes, in violation of a Honduran law that was deemed null and void by the Honduran government. Bobby Unser got lost in a blizzard while snowmobiling and spent almost 2 days trekking through snow in search of aid. After this near-death experience, Bobby was prosecuted for unknowingly entering protected land with his snowmobile. The fact that he got lost in a blizzard was no defense in the eyes of the government. The cost of overcriminalization does not stop with the personal freedom of its direct victims. In my over 25 years as a criminal defense attorney, I have seen families shattered, careers ruined, businesses fail, thousands of innocent workers become unemployed, and entire communities devastated, all done at the taxpayer's expense. This dangerous trend needs to end. The Without Intent report offers 5 basic good government reforms that, if implemented, will potentially stop haphazard federal criminalization. The remainder of the panel will discuss these reforms further, but it is important to note that they have received broad support from a coalition of organizations ranging from the right to the left. This is not an ideological or political issue, but rather a serious and fundamental aspect of good governance. Indeed, all political parties share a responsibility to ensure that criminal laws are properly circumscribed. The problems of overcriminalization are very real, deal with very real people in the very real world of courtrooms across this country. NACDL is confident that today's hearing will heighten awareness of overcriminalization and inspire future action. We welcome this hearing and urge the subcommittee to support rules and legislation embodying these reforms. Thank you.
Thank you. Mr. Unser. Mr. Unser, can you pull the mic a little closer to you?
Is it on?
Wasn't on. Sorry.
That's great.
Not very smart. Thank you, Chairman Scott, and Ranking Member Mr. Gohmert, and the rest of the members of the committee for inviting me here to tell my story about what often happens to honest men and women because of bad criminal laws. The bad law in my case said that I was a criminal if I wandered into a national wilderness that was off limits to motorized vehicles when a friend and I were lost in a blizzard. It didn't matter that we never intended to enter the wilderness. It didn't matter that the wilderness was not marked. It didn't matter that we didn't even know that there was a wilderness there. I could have been imprisoned for up to 6 months for this law. Maybe I should be grateful that I wasn't sent to jail, and I guess I am. But someone else in the same situation might have ended up in prison. I'm here to help make sure that does not happen again, hopefully. Just before Christmas in 1997, my friend and I, Robert Gate and I, planned to go to a snowmobile ride up in what's called the Jarosa Peak area near my ranch in Chaman, New Mexico. That's on the edge of Colorado and New Mexico. It's all in just the state line in between, all the same mountains. The area was known as a snowmobiling location, and it was perfectly legal to snowmobile there. Robert and I headed out around noon and rode for about an hour until we reached a bowl above the tree line that was terrific for snowmobiling. It was exposed at a very high altitude at about 11,000 feet. Our trouble started about an hour later when a severe ground blizzard suddenly kicked up. In a ground blizzard, the wind is blowing so hard that all the snow around you creates what is called a whiteout. That day, the wind was blowing about 60 to 70 miles an hour, and at times, we couldn't see any more than 2 or 3 feet in front of us, just like being in a closet. Almost immediately, we went from playing around to trying to get out of there and find shelter from the blizzard. Less than 30 minutes after the blizzard started and the visibility went down to 0, Robert rode a snowmobile into an embankment and got stuck, which was a blessing in disguise. Good Lord took care of that one. We tried for a few minutes to get it moving, but I realized that it was unlikely that we could get it unstuck, and being abandoned, the snowmobile was good. It was a blessing. So I put Robert on behind me. I couldn't look back and try to guide him out of the mountains is what the deal was. Robert got on the back of my snowmobile, and we started off again. At its best, the visibility was about 20 feet. That's less from here to you. And now we had another problem. I had a brand new snowmobile, and it kept breaking down. Brand new meaning very first trip ever on it. Now, I'm a pretty good mechanic, and under normal circumstances, I could have fixed it and kept it running maybe. But I couldn't get it up and running, and it was getting darker and darker, starting to get dark, which happens at 5 o'clock in that time of the year. We made the decision to abandon it and attempted to get down the mountain to shelter on foot. If we stayed in the high, exposed terrain above the tree line, we were going to die. There was not going to be any question about that. And it was going to be that night. So we had to get down somewhere low enough that there would be trees so that we could build a snow cave. These are the things that I know because I was raised in the mountains. We trudged through the snow in complete darkness, feeling our way down the mountain like two blind men. After a few hours of wandering, remember, no flashlights, no lights of any sort, no moon, nothing to walk by. We trudged through the snow in complete darkness, feeling our way down the mountain like two blind men. After a few hours of wandering, we finally found an area below the tree line where we could build a snow cave. We spent the night in that snow cave, and it sheltered us from the wind. But remember, it's going to get down around 30 below 0 up there, plus or minus a little bit. It's not going to be warm by any means. Snow cave's the only way to make it. We didn't sleep all night, needless to say. The snow cave, just for a minute, had to be, we built it under a tree, a big ponderosa pine tree where the snow gets on the branches, lays the branches down, and I built the cave around the tree, had a little bit circular, and the branches made the roof of the cave. And then we pitched snow up on top of that in order to make the snow cave. Had to do it in the darkness also. The next morning, we had no clear idea where we had come from and no idea where to go. So what had happened there is the blowing snow, I went out the next morning. I would have backtracked to the snowmobile because it was full of gas. Gasoline is safety in the mountains because you can light a fire real easy. But I can't see our tracks because it's all filled back in with snow. The judge didn't want to listen to this. All the next day we trudged through the snow that was never any shallower than our hips. I was very nauseated. And after a short while, I began vomiting repeatedly. Soon after, I started coughing up blood. I was in bad shape. Incidentally, I was only 2 weeks out of a back operation. I was back to Indianapolis, Indiana, got my back overhauled, and maybe I should have been snowmobiling, but under normal circumstances, I could have done it. So we were so cold and near the end of our strength that we didn't not stop to sleep for the end of the second day. We kept struggling on through that night. We were operating on autopilot, exhausted, hungry, and suffering from dehydration and hypothermia and frostbite. Before dawn, we found our oasis, an open barn that had a working space heater and a phone, brand new barn somebody had built, clear down at the bottom of over another range of mountains. And there was a phone in there, believe it or not. Good Lord took care of me again. I called my brother, and then I ended up spending weeks in bed recovering from my experience. But with the help of my friends, family, and doctor, I was able to survive. It's a terrible memory. But all that really matters is that we both made it back alive. After regaining my strength and returning to business, I started thinking about finding my lost snowmobile. It wasn't important before that, because way up in the mountains somewhere. I planned to contact the Forest Service because they have employees who work out in the field almost daily and know the area, so I reached out to them. We first had a short first meeting with a Forest Service employee. This was in Albuquerque, and he told me that he would see what he could do to help. He knew, but didn't tell me that the Forest Service had started a criminal investigation against me. I didn't know this at all. So I came down, it was really the next afternoon. I really thought that they were there to assist me, and I had no idea that they were basically Forest Service police because they never showed me a badge or any credentials. We met with them, or I met with them by myself, and had a conference room and talked right after lunch until after 5 o'clock. I think it was around 5:30 of that day. I told them everything, where we started, where we rode, where the ground blizzard started, and where I thought we spent the first night. Had to just guess at it because I didn't know. They asked me to guess where we might have been. I gave them several good guesses, but made it clear that I didn't know exactly where I was because of the conditions. After we had talked for several hours, one of the Forest Service agents, meaning a lady, reached under the table, opened her briefcase, and pulled something out. It was an official form document they had already filled out and saying they were going to charge me with a federal crime. They claimed I had entered the National Wilderness Area in my snowmobile, which, of course, they had no way of knowing. We were only guessing at everything. So when I found out that they were going to prosecute me for driving my snowmobile into the wilderness area, I told them flat out there was no way I was going to admit to committing a crime. I certainly wasn't going to sign a ticket either. If you can even call it a crime in the first place, I was facing up 6 months in prison and a $5,000 fine, and I had no other option but to fight the charges. I fought the case all the way up to the Supreme Court of the United States, but ended up the short end of the stick because of the nature of the law itself. It seems that because the law was what's called strict liability, the government hardly had to prove anything at all. Under strict liability laws, the government doesn't need to show that the defendant, me, intended to do something wrongful, something illegal, or even know that he was violating the law. That doesn't seem like American justice system to me. Why should I, who nearly died in a ground blizzard, and have to show there was no true need for me to enter the wilderness? Didn't even know I was there. If someone with my ability to fight this case could have made so little headway against the government, then most people charged under bad laws like this will be truly hard-pressed to defend themselves. The long and short of it is that what happened to me was totally wrong. It shouldn't not have happened to me. It should not happen to anyone else in the United States. Laws should not be written so that the government can prosecute us for things we have no idea that's illegal or wrong. Given how the bad situation currently is, I ask Congress to make the changes that this bipartisan group of organizations is recommending. Real criminals, those who intentionally commit robberies, burglaries, and violent crimes, should be properly punished. No doubt about that. No one disputes it. But Americans who are working to do the right thing and stay out of trouble should not be caught up in these traps of over-criminalization. I'd like to answer any questions that you might have. I have a lot to say.
Thank you. Mr. Schoenwetter.
How's that sound? Okay. Good afternoon. Thank you, Chairman Scott and Ranking Member Gohmert, for holding this hearing on over-criminalization. I didn't know anything about over-criminalization until an unjust federal prosecution almost destroyed me and my family. But I'm not here to get sympathy. I'm here to make sure other Americans don't have to go through the same destructive ordeal that we've been through. I am now a convicted felon and just spent 6 years in federal prison because I was a seafood importer and agreed to purchase a typical shipment of lobster. They were packaged in plastic bags like all of the other shipments we had purchased in the previous 12 years. But the U.S. government said the lobster should have been in cardboard boxes because an obscure Honduran regulation said so. That ended up being the reason I was sentenced to over 8 years in federal prison. It may sound crazy, but it's true. I grew up in Brooklyn and learned very early the value of hard work and staying on the right side of the law. Crime was all around you, so you either got caught up in it or you learned to do what was right, follow the law, and stay out of trouble. I had good parents and a strong desire to make something better of myself, so I chose to stay out of trouble. But none of this could have prevented me from becoming a federal criminal. I started a small seafood import company in 1986. It was my little piece of the American dream. My nightmare started in early 1999 when my longtime partner, Bob Blanford, and I agreed to buy a load of Caribbean spiny lobsters from David Henson McNabb, a Honduran fisherman and business associate. The shipment was no different than any of the other hundreds of deals we had done over the years with David. What was different was that the ship was seized and ported at Bayou Labatra, Alabama, by the National Marine Fisheries Service, that's NMFS, a federal agency. Bob and I didn't know the reason for the seizure at the time. Our products had been subjected to FDA and customs regulations, inspections, and random testing for 12 years, and we had never had any trouble at all. We purchased mostly from David McNabb because he delivered the highest quality product on time and was always professional. We never even dealt in the lower quality lobster that was often sold into the secondary market. We eventually learned that the government seized the lobster for supposedly being in violation of Honduran fishing regulations. Keep in mind that we had never seen the lobster before the day it was seized at port. We had no reason to believe that there was anything wrong with it. The government soon told us that they were only trying to make a civil case against David, but that was not true. We soon found out that we were being charged with smuggling and conspiracy based upon violations of Honduran fishing regulations that applied to us under a federal law known as the Lacey Act. The first regulation was the one about cardboard boxes. According to our prosecutors, the second regulation supposedly required that all lobsters caught and sold be at least 5.5 inches in length. The third regulation supposedly prohibited possessing any egg-bearing lobsters. If found guilty, I faced hundreds of thousands of dollars in fines and decades in prison. When I look back on it now, my biggest mistake was exercising my Sixth Amendment right to trial. I had done nothing wrong. I never intended to violate any law. None of us had ever heard of the Honduran regulations. Beyond that, the Honduran government certified to the U.S. government that all three regulations were invalid and unenforceable. But none of this mattered in our case. First, armed agents from the FBI, IRS, NMFS searched my house in Pinecrest, Florida. They forced their way in around 7 in the morning, herding my wife, my mother-in-law, and my daughter into the living room in their night clothes and ordering them to sit and be quiet. Needless to say, we were all frightened to death. Not long after this, another group of federal agents came to my house at 6 in the morning to arrest me. I was not home, but they too had their guns out. I was not a dangerous person. Importing lobsters has nothing to do with violence. And when they finally asked me to surrender, I did so voluntarily. Fighting the unjust charges proved impossible. It all boiled down to a complex relationship between the Honduran regulations and American law. The issue was so complicated, in fact, that the judge was forced to hold separate hearings to determine the validity and meaning of the Honduran rules. Our lawyers presented plenty of evidence showing that the regulations were invalid, including a letter from the Attorney General of Honduras. None of this evidence mattered to the court, however. Despite the absurdity of the law itself, the jury found me guilty of both conspiracy and importation contrary to law, and the judge later sentenced me to 97 months in prison. It took me 5 years to pursue my trial and appeal, and I am still under 3 years of supervised release. All in all, this will be a 14-year ordeal for me and my family, and I will always be a convicted felon. Up until this point, I had been convinced that the justice system would sort out the whole mess. False hope, as it turned out. It's tough to say whether prison is tougher on the inmate or the inmate's family. In my case, prison certainly ground me down. It made me a far less trusting person and triggered a range of personal health problems that I am dealing with to this day. It also cost me my reputation, my livelihood, and my ability to vote. The toll on my family, however, was perhaps even more immense. Last month, on August 27, 2010, I completed the last 5 months of my 6 years and 3 months of confinement. I struggle daily with how to readjust to life after prison and often find myself reflecting how to start my life over. But I owe it to my family and to others who may be targeted to tell my story. I am by no means a lawyer or expert in criminal justice policy, but like most Americans, I think I have a good gut sense of what is right and what is wrong. The law should draw clear, understandable lines between what is legal and what is criminal. When there are so many thousands of criminal laws on the books, none of us can be certain how our actions will be characterized or mischaracterized by the government. The law needs to be simplified, made clearer, and written in a way that gives average Americans an understanding of what they can and cannot do. Simple changes such as these would go a long way towards protecting innocent people from unfair prosecution and unjust prison sentences. Such changes might be too late to benefit my family, but my sincere hope is that they help protect other Americans from the devastating effects of over-criminalization. Thank you for letting me speak, sir.
Thank you. Mr. Walsh.
Good afternoon. Good afternoon. Thank you, Chairman Conyers, Chairman Scott, and Ranking Member Gohmert, and other members of the committee. First, for holding this hearing on overcriminalization's problems and solutions, and also for inviting me to testify. My name is Brian Walsh, and as Chairman Scott said, I direct Heritage's projects on countering the abuse of the criminal law and criminal process, particularly at the federal level. And my work focuses on overcriminalization. The problems of overcriminalization have been well documented academically and even statistically, but the real toll cannot adequately be captured by scholarship or numbers, no matter how skillful. The approximately 4,500 criminal offenses in the U.S. Code and tens of thousands in the Code of Federal Regulations have proliferated beyond reason and comprehension. Surely when neither the Justice Department nor Congress's own research service can even count the number of crimes in federal law, the average person has no hope of knowing what he must do to avoid becoming a federal criminal. The damage this does to the American criminal justice system is incalculable. It used to be a grave statement to say that something was making a federal case out of something, or that someone was making a federal case out of something. Today, although the penalties for a federal case are severe and frequently harsh, the underlying conduct punished is often laughable. 6 months in federal prison for possibly wandering into a national wilderness area when you're lost with a friend in a blizzard and fighting for your lives. 2 years in prison for abandoning materials that you've paid to properly store in 3/8-inch thick stainless steel drums. 2 years in prison for having a small percentage of inaccuracies in your books and records for a home-based orchid business. 8 years in federal prison for agreeing to purchase a typical shipment of lobsters that you have no reason to believe violates any law, and indeed does not. All these sentences and the underlying prosecutions make a mockery of the word justice in federal criminal justice system. They consume scarce and valuable legal enforcement resources that could be spent investigating and prosecuting real criminals or in hearing legitimate civil and criminal cases. By imposing criminal punishment where there is no connection to any rational conception of moral wrongdoing, they severely undermine the public's confidence in and respect for criminal justice as a whole. My written testimony, which I have submitted for the record, focuses on the report that you mentioned, Mr. Chairman, published jointly by the Heritage Foundation and the National Association of Criminal Defense Lawyers. I respectfully request that without intent, how Congress is eroding the criminal intent requirement in federal law would be submitted to the record.
Will, without objection.
Thank you. In short, however, in the report, we found that approximately 60% of nonviolent, non-drug criminal offenses considered in a single Congress, the 109th, had mens rea requirements or criminal intent requirements that are wholly inadequate to protect from criminal punishment Americans who had no intention to commit a crime and no idea that their conduct was illegal or even wrongful. The percentage was approximately the same whether we looked at offenses that were introduced, passed, or enacted. In other words, these are flawed laws with inadequate criminal intent requirements that fail to protect innocent persons like Mr. Unser and Mr. Schoenwetter. We also found that over 50% of these 446 criminal offenses were not given oversight by the judiciary committees that have the express jurisdiction over and most expertise regarding criminal law and justice. The one bright spot comes from your committee, and that is that bills that are marked up or reported out by this committee are statistically more likely to have criminal intent requirements that protect innocent persons. The without intent report was not limited to identifying the problems and causes of federal criminalization. The study was conducted in the context of concerted efforts by the broad range of organizations in or working with the Over-Criminalization Coalition to educate Congress on these problems and develop effective practical solutions. These organizations have met with increasing frequency in the past 2 years with members of Congress and their staffs, leading academics and legal practitioners, and with one another to identify and develop principled, nonpartisan reform proposals. The Without Intent report borrowed heavily from the Coalition's efforts and selected the 5 reforms that are best suited to redress the problems on which the study focused. Several members of the Coalition have begun initial crafting and vetting of legislative language to begin discussing with members of Congress. The hope is that members will adopt some of the ideas in the draft language for their own reform bills. And the current expectation is that bills consistent with such reforms will have bipartisan support. Briefly, the 5 reforms addressed by Without Intent are enacting default rules of interpretation, ensuring that mens rea requirements are adequate to protect against unjust conviction, much like the model penal code already has. Codifying the rule of lenity, which grants defendants the benefit of the doubt when Congress fails to legislate clearly. And this reform is, of course, consistent with our American system's presumption of innocence for the defendants and also its burden of proof that it places on the government to prove every element of the crime beyond a reasonable doubt. The next reform is to require adequate Judiciary Committee oversight of every bill proposing criminal offenses or penalties. The next is to provide detailed written justification for and analysis of all of all new federal criminalization. And finally, it is to redouble efforts to draft every federal criminal offense clearly and precisely. These 5 reforms would substantially increase the strength of the protections against unjust conviction that Congress includes in criminal offenses and prevent further proliferation of federal criminal law. Americans are entitled to no less attention and no less protection of their most basic liberties. The organizations that have been listed today as being in support of this hearing by no means see eye to eye on many important issues, but they have put their disagreements aside to establish common ground on the problems of overcriminalization and develop a common framework for addressing its root causes. This is because there is no disagreement that federal criminal law is seriously broken and getting worse almost every week Congress is in session. In an age of often intense and bitter partisanship, this surprising collaboration speaks volumes. It expresses the good faith of those who share overlapping conceptions of a fundamental goal: to make the criminal justice system as good as it can be and as good as Americans rightly expect it to be. The organizations have differing ideas about how to get to that place, but the broad support for today's hearing is a sign of the similarly broad support for returning federal criminal law to its proper foundations in the fundamental principles of justice. At the end of the day, the most severe toll levied by overcriminalization is human. Racing legend Bobby Unser will be known for life not only for his remarkable accomplishments, but also for his federal criminal conviction. Christopher Evertson is currently unable to care for or even visit his 82-year-old mother in Alaska because he is on probation and living in a ramshackle aluminum trailer on a lot of an Idaho construction company. Abby Schoenwetter and his family must now labor to overcome the unjustified and unnecessary impact of overcriminalization on their health, finances, and emotional well-being. All of these human tragedies came about because an unjust law was written and placed into the hands of an unreasonable government official. These stories testify most eloquently to the irrational justices of overcriminalization. They and unknown victims like them around the country who have not yet had their stories told comprise the thousands of human reasons why stopping and reversing the trend of overcriminalization fully merits this committee's consideration. Thank you again for inviting me to testify, and thank you for your principled, bipartisan stance against these injustices.
Thank you. Professor Smith.
Good job.
Thank you, Chairman Scott, Chairman Conyers, and Judge Gohmert. It's a pleasure to be here to talk about this topic, and I commend all of you for your interest in it. I want to say a little bit about, from an academic perspective, about the problem of overcriminalization. And yes, I think it's a serious problem. Indeed, I would. Sorry. Guess it's on. Can you hear me now? Okay. I think that's on a commercial somewhere. So I wanted to talk about this from an academic perspective. I think there are 2 aspects to overcriminalization that it's important to focus on. One is the usual one that we tend to focus on, which is a quantitative issue. The idea there is that we have too many criminal laws, certainly at the federal level, and those criminal laws are entirely too broad in scope, that there are too many infractions that are punishable as crimes, and that's what I call the quantitative aspect of overcriminalization. There are also, I think, important qualitative aspects. And there the complaint isn't so much about the number of the crimes and the scope of the crimes, but just at how poorly conceived the criminal code is, how inadequately defined crimes are in terms of the conduct or actus reus elements, the state of mind or mens rea elements, the paucity of defenses that are necessary, and similar problems. And in my scholarship, I talk about both of these. I tend to focus less on the quantitative aspects and more on the qualitative aspects. And to be clear, I want to make sure that you don't think that that's because I don't agree with the idea that there are too many crimes and too broad, that crimes are too broad. I totally agree. I think the federal criminal code would work a lot better. We'd have a lot more fairness in our country. We'd be a lot more effective at counterterrorism, for example, and securing our borders if federal prosecutors focused on those issues of truly national concern and stopped playing district attorney. And if FBI agents stopped playing beat cop, leave to the state court system these street crimes and violent crimes, save the resources of the federal government for where they're truly needed, immigration where that's a function of the federal government, those kinds of things. I think a narrower criminal code at the federal level that focused the federal enforcers on those things would be an enormous benefit to our great republic. But The problem I have is I don't want to stake all my bets on the Congress radically reducing the size of the criminal code. I just think it'd be great if it happened. Lots of things would be great if they happened. It'd be great if I hit the lottery. I don't think that's going to happen either. I don't play it, so how can I win it? But I don't know that that's terribly realistic. And so I've tended to focus in my scholarship on the qualitative problems associated with over-criminalization. Can we fix the criminal code so that it more accurately defines crimes? Can we have more realistic punishments, as Chairman Conyers recognized? I think that is an underappreciated part of this problem, and so I'm glad the Chairman brought that up. I think over-punishment is something that we need to be concerned about, and that ties directly in to over-criminalization because federal prosecutors take these broad crimes and they enforce them, and they enforce them because they carry such high penalties. They enforce them because they often have mandatory minimums that ensure jail sentence. And when we move these offenders from the state court system, where drug courts are there, where they're exploring alternatives to punishment, when we move them from the flexible sentencing policies in the state court system into the federal court system, where we have a very rigid, one-size-fits-all approach, punishment, more punishment, and even more punishment, I just think that's a fundamental mistake. We are giving prosecutors incentives to bring these cases into the federal system with all the problems that that causes. And we saw that in the Armstrong case with the 100-to-1 crack cocaine rule, which the Congress rightly repealed earlier this year. Enormous racial disparities in the prison population attributable to this arbitrary and unnecessarily harsh rule about the sentences for crack cocaine. So I think the quantitative aspects are important, and that's where I tend to focus. I do want to make a broader point so that we don't get lost in the weeds, as professors are wont to do. And I think all of this fundamentally comes back to the role of moral blameworthiness in our country. These horror stories we've heard today about over-criminalization are heartbreaking because a fundamental principle of our criminal law is that punishment requires moral blameworthiness, that nobody should be subject to conviction and punishment for a crime unless they committed a blameworthy act, unless they had reason to know their conduct was immoral or illegal. All right? And you can see from these examples we've heard today that our criminal law at the federal level does not do that, that punishment often is imposed without blameworthiness and in excess of blameworthiness, the idea of over-punishment as well. Crimes are not defined adequately. The mens rea requirements in particular in federal criminal law are woefully insufficient. That's a real problem for a criminal law that's supposed to be limited to punishing blameworthy acts, because it's the guilty mind requirement that really ensures that people won't be punished unless they had knowledge that they were committing a wrong, whether a legal wrong or a moral wrong. There are a lot more aspects of this problem. I addressed them in my lengthy statement, so I'll just stop there, and again, I'd be happy to answer your questions.
Thank you, Professor Smith. We didn't repeal the crack and powder disparity. We adjusted it. We improved it. We didn't quite repeal it. We still have a little more work to do. Professor Pacha.
Thank you, Chairman Conyers. Thank you, Chairman Scott and Ranking Member Gohmert, for allowing me the opportunity to speak with you about this important topic of overcriminalization. My name is Ellen Podgore, and I am a professor of law at Stetson University College of Law. I've practiced law as both a prosecutor, a deputy prosecutor, and on the defense side. And I'm now a professor of law, altogether stretching a period in excess of 30 years. I have been teaching and authoring books and articles on the subjects of criminal law, white-collar crime, and legal ethics for many years. And I feel that my background allows me to offer you a balanced perspective on overcriminalization issues that are being addressed by this committee. Clearly, we are all opposed to crime. The goal to eradicate its existence is of the utmost importance. Laws that punish individuals when they commit crimes serve the important goals of deterring future criminality and isolating those who may present harm to society. And as Representative Conyers also points out, educating those who need the education. But efforts towards achieving these goals are hampered by the reality that in some cases criminality is not clearly defined, and society is not properly notified of what conduct is prohibited by law. If we were speaking about murder, rape, robbery, or arson or other common law malum se type of crimes, we wouldn't be having this conversation. We all know these crimes are wrong and that such conduct will result in harsh punishment. The problem arises with respect to malum prohibitum crimes, crimes enacted by Congress that have enormous breadth, crimes that often do not require that the accused acted with criminal intent, and in many cases, crimes that are scattered throughout the 50 titles of the Federal Code. Overcriminalization is a twofold problem, and I agree with Professor Smith in that regard, the number of statutes and the breadth of the statutes. You have my written remarks that elaborate on how overcriminalization increases prosecutorial discretion and judicial creativity, all at the expense of the legislative function. It is important that legislators not assign their lawmaking function to the other branches. I will speak briefly today about 3 solutions that I believe can assist you with solving this problem. With over 4,450 federal criminal statutes, with thousands more regulatory provisions that allow for criminal punishment, and with the numbers continually growing, something needs to be done. First, there needs to be reform of the legislative drafting process. I recommend institute reporting requirements, ascertaining whether there truly is a need for the new legislation and whether constitutional authority was intended to cover that conduct. It would offer safeguards to haphazard legislative drafting and agency-focused initiatives. It also avoids federalism problems that may plague the law when eventually reaching court review. Overcriminalization places financial stress on limited resources, and so there needs to be ample consideration of the costs of enacting new legislation and the resources that are available for implementation. A final component of reforming the legislative drafting process is to require reflection on the overcriminalization problem on an annual basis. This can best be accomplished through data collection of new criminal statutes that are passed to examine how they are used. New statutes that are continually used in tandem with existing laws are suspect as to whether they are truly needed to remedy a gap in the law. The second solution I recommend is to strengthen the mens rea terms in statutes and to provide a default mens rea for the situations when it might be unclear. It's important that federal statutes provide a clear statement of mens rea, that the accused knew his or her conduct was illegal. The American Law Institute's Model Penal Code has a default mens rea, and the Federal Criminal Code should exceed what is required in the Model Penal Code, as it criminalizes malum prohibitum conduct that is not always nefarious or presumptively considered illegal. Having a specific mens rea terminology in statutes and a default mens rea as a safety net may still leave gaps needing interpretation. So the third solution I would recommend is to codify the rule of lenity. The rule of lenity requires ambiguous criminal laws to be interpreted in favor of the defendants subjected to them. As Chief Justice Marshall in 1820 noted, it is the legislature, not the court, which is to define a crime and ordain its punishment. Some states have moved in this direction. My own state, Florida, for example. Overcriminalization is a flaw of our criminal justice process that needs a remedy. I do understand that it's difficult to change the existing mentality of addressing immediate problems with criminalization. The solutions recommended here take an important step in restoring the importance of the legislative role. The cycle of recriminalizing conduct every time an event occurs needs to stop. Thank you very, very much for this opportunity today.
Mr. Weissman.
Good afternoon. The perspective that I would like to share with you this afternoon is as a former member of law enforcement. The proposals in the Without Intent report would bring much needed clarity, in my view, to the criminal law. You have heard today from various panelists about how the proposals would benefit the public and not just putative defendants. A question can arise as to what the potential downsides are of these proposed reforms to law enforcement. As a dedicated federal prosecutor for up to 15 years, I can tell you that these proposals would have no drawbacks for law enforcement. Indeed, in my view, they would serve to benefit it. Let me give you two examples. First, requiring criminal bills to state clearly the mens rea requirement would serve to assist prosecutors in guiding their decisions as to who to investigate and who to charge. It would benefit the courts in knowing how to charge a jury, and benefit, of course, defendants in being held accountable only for conduct that clearly violates the law. One example I can give you is the prosecution of Big Five accounting firm Arthur Andersen, in which I served as the lead attorney for the government. The federal district judge was faced with an obstruction statute that required the defendant to act intentionally and, quote, corruptly, unquote. The definition of the latter, however, was not spelled out in the statute, and thus the court followed precedent that the Supreme Court only years later determined to be erroneous. The Supreme Court itself grappled with the term corruptly and what it meant. The Federal Criminalization Reporting Statement advocated by the Heritage Foundation and the NACDL could have led to a much more just outcome. Instead of a company facing indictment for a crime whose elements were not, in retrospect, crystal clear, the government and grand jury would have been able to determine prior to indictment whether the conduct violated the terms of the statute. Further, if the grand jury went forward and voted an indictment, the company would have been able to defend itself at the trial based on the clear requirements of the criminal statute and not have to await 2 levels of appeal, which in a corporate setting can render any relief pyrrhic. Indeed, by the time the Supreme Court ruled in the Andersen case, the organization was basically out of business. Thus, in answering whether the proposed reforms we address here today are wise, I submit we need only imagine the answers of the prosecution, the defense, and the court in the Andersen case to the question of whether they would have preferred that Congress specify clearly the intent standard in the obstruction statute. In short, lack of clarity in the criminal law can have real and dire consequences which are antithetical to the very goals of the justice system. There's a second way in which the proposed reforms would be beneficial. The rush to enact a criminal statute to address perceived criminal problems can be illusory. The issue is often not the absence of criminal statutes on the books, but of investigation and enforcement. Often the conduct at issue already runs afoul of existing criminal law. In such situations, enacting a new criminal statute is not only redundant, it can be counterproductive, since it focuses our time and attention on a measure that actually will not serve to reduce the risk of recidivism. For instance, in the immediate aftermath of high-profile national crises, such as the corporate scandals, the meltdown on Wall Street that we've recently seen, or illegal immigration, there is a natural desire to take action that will reduce the risk of recidivism. Such actions often include the passage of additional criminal statutes. And while those statutes can be useful and sometimes extremely well crafted, in the heat of the moment, they can also be ill-advised, redundant, and vague. For instance, in the white-collar context, hearings last year in the Senate addressed a bill that would have simultaneously created a uniform fiduciary duty on all financial institutions to their clients and criminalized breaches of that duty. But there already were abundant tools available to federal prosecutors to prosecute such conduct. As has been noted by various panelists, the United States Code contains numerous provisions that would criminalize such conduct, for instance, the mail and wire fraud statutes. To win a conviction, a prosecutor need only show that a defendant used the mails or wires as a part of a scheme to defraud. Any email could suffice. Here, an anecdote may be illustrative. When I was a prosecutor switching from organized crime prosecutions in New York City to prosecuting financial fraud on Wall Street, I sought advice from a senior white-collar prosecutor about the intricacies of the securities laws. His advice: get to know the mail and wire fraud statutes really well. Everything else is gravy. In conclusion, I would note that the line separating criminal conduct from all other is society's starkest boundary between right and wrong. It should be reserved for actions taken intentionally. The goal of reserving the criminal law to those truly deserving of the highest punishment of our society would be greatly served by enacting the proposals put forward to you by the Heritage Foundation and the NACDL. Thank you.
Thank you, and I want to thank all of our witnesses for the testimony. This is extremely helpful. I'll now recognize myself for questions for 5 minutes, and start with Mrs. Podgore. Without taking an hour to do it, as you usually do as a professor, can you just give us a description of why malum per se and malum prohibitum would require a mens rea requirement?
It all comes back to punishment. If we want people to actually know why they're being punished so that they don't commit the crimes, then it's very important that they know that they're committing the crimes. And I think the witnesses who testified today are the perfect example of just that. Whether it's malum prohibitum or malum se, there needs to be a mens rea. The basic difference is that in malum se crimes, there usually is that mens rea. It's there. In the malum prohibitum crimes, the ones that are passed by the legislature, we don't find that mens rea, and people just don't know that it's wrong. And if they don't know it's wrong, then even if we punish them, it's not going to serve that goal if it's not known. And so if we want to succeed in stopping criminality, then we have to put the mens rea in so that people won't commit the crimes.
You mentioned the rule of lenity. With the presumption of innocence, why isn't the rule of lenity automatic?
The presumption of innocence goes to the factual decision in a case. The rule of lenity goes to the interpretation of the law. And when you have two constitutional possible interpretations of the law, the court is faced with the decision of which one they should go with. The rule of lenity allows them to go with the one that would be more persuasive for the defendant. And so it's different than just a presumption of innocence, which would be looking at the facts itself.
But when you add guilt beyond a reasonable doubt to that, why wouldn't the court be required to pick the one most favorable to the defendant?
Well, reasonable doubt only goes to whether the person has committed the crime itself from a factual stance. Do they have sufficient evidence of that particular crime? But if we don't know what the crime is, then the problem becomes, have they committed it or not? Even if there is, we can't even get to the question of reasonable doubt. It's the reasonable doubt question would really be our second question after we determine what the law is.
Mr. Walsh, can you talk a little bit about the problem of allowing regulators to create crime without going through the normal legislative process? When regulators can decide when it's a crime and when it's not?
Certainly, yes. One of the things that, coming from the report that we found when we were doing our study, was that a large percentage or a significant percentage of crimes that were passed by the legislature actually authorized the agencies to create even more crimes. There wasn't necessarily a limitation on how the agency had to do it. In other words, there wasn't a requirement of whether there would be criminal intent or what the scope of the conduct was that would be prohibited. And so there's no telling when Congress creates those types of crimes how many additional crimes end up being created by that, which is one of the reasons why Professor John Coffey from Columbia has reported an estimate that up to 300,000 federal regulations may be enforced by criminal penalties. So the issue becomes, of course, that if something's important enough to send a person to prison, it really should be the people's elected representatives who are making that decision and not delegating it to unelected agency officials. I don't mean to say it in a demeaning way, but bureaucrats in the executive branch. It really should be a decision that's made by those who are elected by the people. So there's a separation of powers issue as well, I think, that is implicated there, and that it's the job of the Congress to make a decision about what the law should be. And especially in the area of criminal law, in particular when somebody's deepest rights and liberties are at stake, that's something that really implicates some constitutional issues about whether the agencies in the executive branch should be making those decisions.
Well, many of these are very important regulations, and we expect them to be, for people to conform with the regulations. How do you enforce those regulations if you do not have the criminal code?
Well, one of the ways, I mean, you can absolutely do it if you have a meaningful criminal intent or mens rea requirement, because in that instance, the individual is on notice based on something, whatever it might be. Maybe it's a person who's in a highly regulated industry and has been informed or knows the standard industry practices, and there's actual evidence that the person is on notice that this is what the regulation is. But apart from that, one of the ways to punish it is, in the first instance, civilly. So the first time that somebody violated one of these regulatory offenses, and if there is no evidence of mens rea or criminal intent, then a civil punishment is appropriate in that context and would really fulfill the requirements of justice. On a second offense, then you could actually say that the person, especially if it's the same person with the same offense, they've been put on notice, and maybe subsequent offenses could be punished using criminal offense penalties.
Thank you. Judge Gohmert.
Thank you for all of your wonderful observations, very helpful. And I've just been looking at some of these statutes that we're talking about, and it causes me great chagrin to note some of the laws, like Mr. Unser, in your situation, apparently, since we've passed a law that says, the Forest Service can promulgate regulations, and if you violate one of those, it's the law, we inserted the words, or such rules and regulations shall be punished by fine not more than $500, imprisonment not more than 6 months. It's the insertion of or such rules and regulations that apparently caught you, because there is a provision that Department of Interior, some part thereof, says that possessing in a national forest wilderness, possessing or using a motor vehicle, motorboat, or motorized equipment is a crime, and also such terribly heinous activity as possessing or using a bicycle in a wilderness would get you the same 6 months. So be careful where you ride your bike. Unbelievable, and I appreciate the comments that perhaps we ought to be restricting the threat of prison to those things we actually take up and actually come before the judiciary. Mr. Walsh, you've indicated we have a better percentage of cases in which laws we've passed actually included mens rea requirement or in criminal intent. And so hopefully that would be one area in which we can work. But I wanted to follow up with a couple other questions too. Mr. Schoenwater, after the Attorney General of Honduras submitted his letter saying they didn't think that you had violated Honduran law, what was the prosecutor's response? Did you see or hear what the position of the prosecutor was?
We had a witness against us, a Liliana Paz, who was a mid-level official that had testified that we did violate Honduran regulations. They were in effect. And the position of the prosecutors was that the government of Honduras was changing their opinion of the case. In other words, they changed their position, and not so much the prosecutors, but in the 11th Circuit, they inferred that in a place like Honduras, government officials could be paid off in order to change their position on different ideas. So they just disregarded that. I also like to say that we also had a letter from the president of Honduras to our president asking, not for myself, but McNabb, my co-defendant, who had some, he was well known in Honduras. The president wrote a letter on his behalf asking for the president of the United States to intervene in this, and that was ignored also.
Well, apparently the law, which created the net that caught you, it says it's unlawful for any person, and it goes through to import, export, transport, sell, receive, fish or wildlife, taken, possessed, transported, sold in violation of any law or regulation of any state, or in violation of any foreign law. You know, there was a time when most of us, and it sounds like all of the reasonable minds here, would say, and in talking to Chairman Scott, I mean, we're just shocked, because our feeling is, what prosecutor would take a case like this? You know, if you'd told us, you know, a couple of years ago, no prosecutor in his right mind would take these cases, well, maybe that's right, but maybe we got a lot of prosecutors who are not in their right mind because they're taking these cases. You know, we're just shocked. And I know, Professor Smith, from your comment, surely as a professor, if someone had come up and given you these hypotheticals, you would have said, no, I know enough prosecutors, no good prosecutor would take a case like that. But apparently there are a lot of prosecutors perhaps that aren't good that are taking them. But what, let me ask, and I appreciate the Chairman's indulgence, but Mr. Unser, I wanted to ask and get clarification. Were there any markers that marked where you went into the wilderness area, to your knowledge?
There, excuse me, there are absolutely 1,000% none, completely none. Charlie Bird, excuse me, frog in my throat. Charlie Bird, the...
Did that come from a wilderness area?
Yes, sir. He's, yeah,
yeah, be careful.
from up there.
You have the right to remain silent.
But he made a fool out of himself right in the court by not understanding himself where the wilderness area was, what he was issuing me a ticket for. In other words, when you talk about that Jarosa area, thousands of people snowmobile up there. Nobody gets a ticket. It's legal. He thought the wilderness area went clear out to there. He didn't even know that people had been snowmobiling in that area. But the wilderness area was, in fact, a long ways west of there. And that came right out in the court. It's in the court records now that nobody can hide. It was just like a jury-rigged deal. He could lie as much as he wanted to lie, and the judge would accept it as much as he wanted to accept it. Well, it's just that simple.
If you just watch TV, you know that normally when there's a law enforcement person who is going to ask you about something and they suspect that you have committed a crime, you get read your rights. Did anybody at any time before you were being charged or told you were being charged advise you that you had the right to remain silent and not tell them where your snowmobile was, that they suspected that you had violated the wilderness area?
Not only did they not do that, I have airplanes also. And I have a special airplane that would do high altitude and slow flight. I described to millions of people, in fact, it had to be hundreds of millions of people all over the world. Those articles that I let out way before the court thing went all over to every non-communist country on this earth. At least that's what it was rumored to be. and I described where I left my snowmobile as an example. That snowmobile, when they showed up 1 week before the trial, 1 week, that's in June, not the summer, there's no snow. They finally showed up, theoretically had found my snowmobile in trees. The snowmobile was under trees, so I couldn't see it from my airplane because Charlie Bird, the government cop, it had it moved. In other words, I sent pictures to all the
Somebody
people
had
at
moved it.
Heritage.
Yeah.
So, well, for sure somebody
Somebody
moved
had
it.
moved them.
Because why would I describe it being out in the open when I don't know that I've committed any crimes?
Right.
So I would have no reason to lie or tell a story, but it shows up 1 week before the trial. But they didn't give us a picture or even let us see that. And mens rea or warning.
Did you give him his warnings that he had a right to remain silent after it was found in?
Yeah.
But well,
It
obviously
really got
I'm
bad, but it
being
made
a
no
bit
difference.
facetious about something that is so serious, where people have lost their freedoms as a result of overzealousness. But just if I could have one more moment of indulgence, Professor Smith and actually Professor Parker, you both addressed the rule of lenity. Why do you think in these cases there is hostility toward not having an ambiguity afforded in the direction of the defendant? Do you have any explanation?
Sure. I think there are a couple things. One, there are some sort of tough-on-crime judges who just would prefer that criminals go to jail, and they don't want an interpretive rule that makes it hard for them to send criminals to jail. I think that's one part of it. I think another part is the lack of judicial humility. I mean, they think they can make the decisions necessary. They think they can, most judges think they can decide reasonably, certainly as reasonably as this body, and in their view probably more reasonably, what should and shouldn't be a crime. So they roll up their sleeves and put on their thinking caps, and they take these ambiguous statutes and they just construe them to make the case come out right. Now, it's important to remember that unlike when a Congress or a legislature passes crimes, it's acting in advance of a legislative act. Courts are acting retrospectively. The conduct has happened, all right, and they're deciding whether that past conduct should be a crime. So they look at that conduct, and if it's a bad person, however one might describe that, they want to make the case come out right, which is to send that person to jail. And I don't know, and that's just an unprincipled approach to this. They're basically making crimes, which is fundamentally at odds with our system. The legislature, and only the legislature, is supposed to declare crimes, and yet when courts take these ambiguous statutes and in violation of the rule of lenity expand them, they're declaring criminal acts that the Congress hasn't specifically made a crime. I think they're also overriding legislative judgments about penalties as well. These are things that should be reserved for the legislature, not the other branches. And Judge Gohmert, you brought up the issue of prosecutorial discretion. I think most prosecutors are professional, but I think it's dangerous. I mean, you know the phrase, absolute power corrupts absolutely. Well, that's what over-criminalization fundamentally is about. It's about giving prosecutors, the executive branch, absolute power. And it's not just the executive branch, it's each and every prosecutor. The hundreds of prosecutors across this country all have absolute power in their own areas. And so any prosecutor with an ounce of sense, maybe even a half an ounce, would have not charged Mr. Unser for this offense. But he was still charged and convicted. And these two examples here are examples of prosecutorial discretion fails. And I think it's important for the Congress to realize it fails quite a lot. The presumption of innocence, I think, is turned on its head. That's a legal construct. It doesn't apply to prosecutors. Prosecutors, I think, decide, well, Mr. Schoenwetter must have been up to no good, and we can get him on this. And so what if it's unfair to get him on this? We know he's up to no good. And it's that kind of speculation that drives prosecutorial decisions. And that's why I think it's so important that the crimes fully define the blameworthiness of the act, including the state of mind that's required. Because then they're being forced to prove their suspicions in court. They're being forced to prove moral blameworthiness. And so if they were required to show that Mr. Schoenwetter knew that he was breaking Honduran law, he would have been acquitted. But I think they can, because that wasn't an element of the crime with which he was charged, they could just say, well, we think you knew, and if you didn't know, you should have known, and so what if the president and the attorney general of that country say it's not a crime? We know it is. I mean, it's that fundamental hubris that happens when you give prosecutors absolute power. In Mr. Unser's case, it's even a more basic issue. There is a key fact necessary to the blameworthiness of his act, that he's in a federal wilderness area. The crime doesn't even require him to have that factual knowledge. No wonder these horror stories happen. It's dangerous when you give any official, no matter how well-intentioned, absolute power. That's what overcriminalization does, and I think it's high time for Congress to assert its supremacy in this area and to require courts to help counteract instead of facilitate overcriminalization.
Professor Piper, did you have a comment?
I have nothing to add to that. I agree with it wholeheartedly.
Well, thank you. All right, thank you, Chair.
Thank you. Mr. Conyers.
Thank you, Chairman Scott, and your ranking member who've done a good job on this committee. We've covered so many subject areas over the years coming out of the Crime Committee. I'd like to ask this question of whether or not we should begin to put together some sort of bank or place to house all of the Unser, Schornmeister cases in America. I mean, we've got 2 here, but can you imagine how many there might be if this committee, not to invite for hearings, because we'd become a inferior court of our own, but what about a place to capture this information that would serve as a reservoir for our 5 other experts that are here to begin to get a larger picture of this? It seems to me that we have 2 cases. If you give me, well, I guess we'll be talking about the next session of Congress now, because we're almost out by next week, it's predicted. But there ought to be a place where people can communicate any problems of this nature, and they would go into a specific place. The problem is that right now, members of Congress get letters about these kinds of cases, the Unser case, the Schoenwetter case, but they're of individual cases in their congressional district. And I suppose senators get the same thing in their state. So what if we were to put these into, say, the Crime Committee or another body designated by the Crime Committee, so that there would be a repository in the American legal system of what has happened, to give us a clearer picture, and we wouldn't have to hold an almost infinite number of hearings, hearing special cases of other people that are so aggrieved. And could I invite our distinguished witnesses, Brian Walsh, you want to take a crack at that, please, sir?
Mr. Chairman, I think it's a terrific idea, and I can't say that it's quite to the level or the extent that you've suggested yet, but there have been some efforts that we've undertaken in collaboration with others. I know that NACDL, for example, collects these types of cases, and now also we have an overcriminalized.com website where we have begun to publish these stories. And so it is an opportunity for us to have a sort of a central place. People will email us on a fairly regular basis, and not all of the stories have been published yet, but we would certainly be interested in pursuing that. One of the other features that we developed with NACDL was a list, notification of new bills going through Congress that actually have these types of provisions in them. And people can subscribe to that, the legislative update alert. But we're working to try to do exactly what you're suggesting, and we would be delighted to work further with the committee to help develop that even further. Professor Smith also encouraged me to mention One Nation Under Arrest, which is a book that we published that has some of these stories in it, about a couple dozen of them. So,
Chairman Conyers, I agree with that. You always have to. Oversight is an important function of this body, as you know, and that's fundamentally what you're talking about, oversight of how the executive branch is handling these cases. And so I think that's important to do. But I do want to caution, though, we've been focusing a lot on these sort of esoteric, sort of highly technical crimes. And it's easy to do that. You get a lot of fair notice problems are very serious there. But the problem of over-criminalization exists even with real crimes. I think this goes back to something Judge Gohmert mentioned. Even real crimes that we all would agree are heinous, immoral acts. You still have poor crime definition causing problems there. For example, the federal child pornography statute. It requires, as passed by Congress, you have to know you're receiving something, and you have to know that the thing you received is a visual depiction. That's all Congress said about the mens rea requirements. What don't you have to know? What matters? You don't have to know that it's sexually explicit. You don't have to know that it's minors engaging in sex. Congress did not require mens rea. Those are the things you need to know. Those are the facts that are essential to saying its blameworthiness. And the Supreme Court construed that statute, and they read in a mens rea requirement, so they fixed that problem. But the fact is, it was a problem. The fact also, going back to prosecutorial discretion, is the Justice Department argued in that case, the excitement video case, oh, you don't have to know it's sexually explicit conduct involving minors. As long as you know it's a video, that's enough. I mean, that's insane, all right? But the point is simply to illustrate again the limitations of prosecutorial discretion, and also to see that even when we're talking about real crimes, mala in se, real crimes, crimes that should be punished, there too you have problems with crime definition. So it's not just the technical regulatory offenses, it's all crimes. That's how deep and corrosive the problem of overcriminalization is.
Well, you're quite right that merely collecting these without making that kind of analysis would be overlooking a very huge part of the problem. What about the president of the Defense Lawyers Association? How does this strike you, sir?
Well, certainly we are in the process working with Heritage Foundation and others to try and collect the anecdotal evidence to support the reforms that we're asking Congress to enact. And part of that deals with the two separate issues, as Professor Smith discussed. One is the over-criminalization issue itself, and the requirement that statutes are particularly described with the conduct that the citizen should know is wrong, both the act itself and the mental state that goes along with it. That's what we've been talking about for the last couple of hours and weeks with this report. The other issue is over-federalization. If I may be so bold as a perspective from a practicing lawyer who has been trying cases for over 36 years, 11 years as a prosecutor, 25 years as a defense lawyer, the reality is prosecutors don't often use the appropriate discretion, and when they don't, judges are not acting independently, which is why we are suggesting the rule of lenity, and where you really need to put this in perspective. Judge Gohmert's perspective is a state court judge in East Texas, where it was his fiefdom. Judge Poe was the same thing. Nobody would say that these judges were not independent. But in some federal circuits, the reality is otherwise. The judges rubber stamp what prosecutors do. So in the context of what we are attempting to do is to collect these anecdotal stories, to eventually being able to present them to you so that you can see not just the construct that we're talking about here, that we've really been using, the without intent report, is to give you the basics of the 109th Congress and how that was a snapshot of things that were wrong in that context. Obviously, the problem is much larger than that. And when you see it here, you assume that judges would exercise discretion in Mr. Schoenwetter's case, and you assume prosecutors would exercise discretion in Mr. Unter's case, but the fact is they didn't. And in the Georgia Thompson case we spoke about earlier, they didn't. And the reason they didn't is manifold. Maybe their local politics. Maybe the regulatory agency is looking to justify its budget for that year and has to have so many scalps. Maybe that regulatory agency, I suspect, in the Unter case was pushing the local prosecutor. And the judge did not have the independence, we might call it something else that might not be public, to say that this is wrong. The statute cannot be read this way. There has to be a mental state, an intentional construct to it. There has to be a conscious objective or desire to engage in conduct that is in fact wrong. So to answer your question shortly, yes, we will do everything we can to attempt to collect these and find maybe perhaps a way to get them to you in a repository that would help you to expand some of the issues we've talked about here today.
Well, thank you so much. I just close on this, Chairman Scott and Judge Gohmert. I still think that the drug problem, am I right that we put $1 trillion in fighting the so-called drug war over the last decades? We're not sure how much money we've spent. But the whole idea is that we've put an enormous amount of federal money into this. States have also put an enormous amount of money. And yet, the treatment of this offense as a health problem is minimized. Many people are imprisoned with a health problem which is only aggravated certainly while they're there and maybe even worse when they get out. And it overlooks a sort of more common sense approach so that the last thing that I think makes this a good idea is that more than anything else, we educate the American people, the citizens themselves, begin to understand the kind of problems that we have taken up here today with all of you experts. And so I thank you very much for the time, and I hope that we can continue this discussion after this hearing.
Thank you. I had one final question for Mr. Walsh. You've presented subcommittee staff with a draft legislation as to what we should be doing about reform. Can you describe that legislation to us?
The draft is based on the recommendation in the without intent report that basically would require Congress to analyze what it is that it's doing each time it criminalizes. So any new or modified criminal offense or penalty that went through Congress, the recommendation would be in that legislation that there would have to be a report generated before there was floor debate on the criminal penalties. There's already so much criminalization that it makes sense that if there's going to be any new criminalization, Congress should have to describe what's the problem that we're trying to solve here with specificity. How does the mens rea requirement supposed to work? What about existing federal and state law, and how does that overlap with the new law that's being proposed? In addition, how does this impact the federalism implications? What are the implications for that both Mr. Levine and Professor Smith have mentioned and others during this panel? So that list of requirements would basically give Congress help Congress really to stop, look and focus at the work that it's doing in criminalization, decide whether this is really needed. Is there really a motivating factor, or could this already be charged? Many times the crimes that we hear about that result in new criminalization are in fact charged. One of the great examples of this is the carjacking offenses that ended up being federal crimes, and yet those specific crimes that were used is a horrible, tragic crime, but the perpetrators were both sentenced to life sentences in Maryland. under state law. So there's already existing law. There wasn't need for federal law in that case. So explaining what it is that Congress is doing, and in addition, the recommendation of NACDL and the Heritage Foundation that's embodied in that legislation would be that the agencies would have to describe all of their new criminalization. Right now, there's so much of it that it's hard to really get a handle on when the agencies propose rules that have criminal penalties or offenses in them. And in addition, whenever they make a referral of to the Justice Department for prosecution, what is the criminal offense that that in statutory code that they are saying justifies this criminal referral? What's the regulation in the Code of Federal Regulations that justifies it? And that basically puts them on notice and also puts Congress on notice of how these new laws and these new regulations are being used. So that's the general gist of it, and we think that there are some really good points in it that would be useful to the committee for its consideration as it's considering legislation.
Thank you. I had a conversation with somebody earlier today, and we mentioned carjacking. And if you're a victim of carjacking, you do not call the FBI. Call the local police.
That's right.
Judge Gohmert?
Yes. Thank you, Chairman. Well, in looking at this, and of course, Mr. Walsh, the book you put together, One Nation Under Arrest, really eye-opening. And I had mentioned before, it makes Kafka's novels look tame compared to what we've done to people, all the uncertainty. And when I look at a law like this that so grievously adversely affected Mr. Schoenwetter, when you include language in a law that says in violation of any law or regulation of any state or in violation of any foreign law, we just embraced every foreign law in every country. And I know this was passed before I ever got to Congress, but I bet there's language in some that have been passed more recently that include broad language like that. But we have no business embracing all foreign laws. And I would tend to think that one of the solutions from hearing our panelists, all the testimony, was that I'm not sure that we should have any law that's punishable by incarceration that is not made a law by the legislative body. Leaving that to regulators that know they're unelected. Some of them are unappointed. They're certainly unconfirmed. They're just unaccountable out there passing regulations as they see fit. Heck, they may have even come up with a regulation that says you can't park one under a tree for all we know, but a snowmobile. It just, if it's serious enough to take away someone's freedom, then it ought to be serious enough to come before Congress. And then, of course, the criminal intent issue, to require that where there's no mention that there has to be some criminal intent. These statutes that captured the apparent innocent acts of Mr. Schoenwetter and Mr. Unser, it appears to be a knowing requirement, but not knowing of any violation, but knowing that you were on a snowmobile or knowing that you were purchasing lobsters. And I'm not sure how much sense that made. I would have thought perhaps that lobsters would be safer and cleaner in a plastic bag instead of cardboard. Who knew? But anyway, it just seems like if it's important enough to take away somebody's freedom, it ought to come through a legislative branch. And Chairman Conyers, I know that you and Chairman Scott have both made a great deal of effort over the last 3.5 years to do oversight, but there is just so much to do. And I think you did better perhaps than we did my first couple of years here. but I appreciate your efforts in that regard. But we can see there's just so much area that needs oversight. We better clean up the laws so that it's not quite so broad in the areas of abuse, so that there is not as much discretion as Professor Smith points out has created some of the problems. But appreciate former Attorney General Ed Meese's efforts in trying to push this and bring this to the forefront. And regardless, you never know how politics is, whether Democrats or Republicans are in the majority after this. It doesn't matter. This is so serious. We're talking about people's freedom and the way it adversely affects people's faith in their government or lack thereof. We got to get this cleaned up, and thank you very much for helping us bring this to the front.
Chairman Scott, excuse me, can I make a
Yes,
remark
sir.
in regards to something Judge Cowart said?
Yes, sir.
You talked about the Lacey Act. What happened with us was that, and this is to the best of my recollection, the Lacey Act was rewritten. The original Lacey Act said any law or any foreign law or regulation. The rewriting of it said any foreign law. So we objected on the grounds that we were accused of violating regulations. It was semantics, of course. But the judge found that it was the intent of Congress to add regulations into that they just forgot to do it. So actually, I think I was sentenced to 8 years in prison because Congress intended to put in regulations but decided it just was understood.
So when I talked about in terms of us allowing federal, unelected, unaccountable bureaucrats to make regulations that capture people, heaven knows how those regulator makers in other countries were doing that.
Absolutely.
And it sounds like in Honduras, they certainly disagreed with our government's approach to their own laws. So I appreciate that point. Thanks, Chairman.
Thank you, Judge Connor.
Mr. Conyers? I just had one last question for Professor Podgord. Would one short bill be sufficient to create a default mens rea?
I think so. It is one provision within the model penal code, so I see no reason why it couldn't be accomplished with one short bill.
If not, I want to thank all of our witnesses for your testimony. Without objection, the joint report, Without Intent, How Congress is Eroding the Criminal Intent Requirement in Federal Law by the Heritage Foundation and National Association of Criminal Defense Lawyers will be included in the record. The memo, Enacting Principled Nonpartisan Criminal Law Reform, a memo to President-elect Obama by Brian Walsh, will also be included in the record. The hearing record will remain open for 1 week for submission of additional materials. And we may have written questions for you. If you would respond to them, if they're sent to you as promptly as possible, your answers could be made part of the record. And without objection, the subcommittee stands adjourned. Thank you very much.
All right. I wonder if I can get up.
First video has reared its head again.
Wow.
Thank you so much.
Thank you, Brian.
Wonderful job, Abby.
Right. Was I all right?
You were great.
This?
Yes.
Thing about the Lacey? Thank you, bro. You're so